Blessings, beloved. Jesus is the way and the truth and the life, and no man cometh unto the Father but through him. So it's currently -2. I'm in my bag on the St. Peter's Square in Wexford Town. And today there is a hearing in the Court of Appeal. It's Stephen Tallon versus the DPP. Now, the appeal hearing was granted a month and 4 days late, and there was no application to appeal entered in for an extension. So, the application for appeal was entered in, but the application for an extension to appeal was not entered in. There was no application for an extension to appeal, and therefore the court couldn't lawfully accept the appeal. But yet they've brought it to the Court of Appeal, these experts in the law, knowing that they haven't fulfilled the administrative procedures and protocols necessary. So the Court of Appeal is now operating outside of jurisdiction. In other words, the Court of Appeal isn't operating. It's a rogue court. All the way along, the courts have been doing things of a rogue manner. Many of the times it was done to conceal what was going on in the courtroom from the people so that it could go on unnoticed. But certain people have been following the court case. The Court of Appeal have to know that there are a lot of eyes peeled watching them, and there are a lot of people whose eyes are peeled who have qualifications in the law. So these people who are now operating in the Court of Appeal in Dublin should know that you're not going unnoticed. Your conduct is being noticed by people who are versed in the law. So this won't go unnoticed. And I want you to do what's right. You need to recognise that members of An Garda Síochána have no jurisdiction in civil matters. The adult behaviour warnings cannot be lawfully ratified from section 113, 114, 115 and 117. A guard cannot summons you before a civil court. A guard cannot represent or prosecute on behalf of somebody in a civil court. A guard cannot do in a civil district court what they cannot do in a criminal district court. They shouldn't even be in the civil district court. What do I mean by that? A guard isn't allowed to go in and represent another guard's evidence. This was ruled on quite recently, and it's not allowed to happen. Yet they're calling the superintendent to represent 3 different guards while prosecuting a group of people he has favoured over another person without reason, showing bias. Now, I say without reason, meaning no good reason. Of course, there's a conspiratorial reason for doing it, but it's not lawful. And so a guard, what he can't do in a criminal jurisdiction, he can't sneakily do in a civil jurisdiction, hoping that he's out of sight and out of notice. The legislations 113, 114, the sections rather, 113, 114, 115 and 117 of the legislation of the Act, which is the Criminal Justice Act 2006. The Criminal Justice Act 2006. That is, again, I say the Criminal Justice Act 2006. Sections 113, 114, 115 and 117 of the Criminal Justice Act 2006 are unlawful. They cannot be lawfully satisfied. They cannot satisfy the presumption of innocence, jurisdiction, impartiality, due process of law, and everybody being held equal before the law. They do not satisfy the jurisdictional qualifications for a member of An Garda Síochána. In other words, a guard can never qualify as someone to prosecute somebody he has arbitrarily chosen to represent, when he cannot produce any solid irrefutable evidence and he cannot operate in a jurisdiction outside of the criminal one. So what we're seeing here is a deliberate neglect on the part of the High Court to address the testing of the constitutionality of the sections 115 and 117, but at the same time quashing all of my convictions. Why? Well, they could later be appealed if it was done in the absence of the testing of section 115 and 117. But if they were quashed as a result of section 115 and 117 having been tested for their constitutionality or constitutional relevance, and being found unconstitutional by so being tested, well then obviously those convictions that arrived as a result of this utilisation of section 115, 117, 113 and 114 would have been unlawful. And so anything that came as a result of that would have had to been quashed without the ability to appeal it or kick it down the road or appeal to a higher court and try and establish some case law. What they're doing here is highly unlawful, highly evil. It's a corruption of our state and of our government. It's a corruption of our High Court, our now Court of Appeal, because they've accepted an appeal a month and 4 days late, showing that they're interested in the things of the state by so doing. So how do you expect to get a fair hearing in the Court of Appeal when the Court of Appeal are accepting appeals a month and 4 days late without having received an application for an extension to appeal? An application for an extension to appeal is when you know that you're out of the time limit applied in order to appeal a case. And you have to apply first then for an extension to appeal. You're asking for more time to appeal. Now, there's no good reason why that would happen, given that the High Court is better qualified than the state to estimate whether my conviction should be quashed or not. Why would the High Court be submitting to an appeal from the state? That is, if it has tested everything according to the Constitution. There are barristers at law there. But I will say this, the right to appeal is never removed, and so it just, to me, it doesn't make sense that the Court of Appeal would be accepting an appeal a month and 4 days late without having received an extension to appeal. They would have had to apply for an extension to appeal. They would have been granted it. The court would have received that notification of that extension, and then the court could accept the appeal. But none of that happened. They did not apply for an extension to appeal, and therefore they can't sit lawfully today and establish jurisdiction, because the administrative procedures and protocols of the court were not established, and therefore neither was jurisdiction. But aside from all of that, the High Court failed to complete the schedule presented before them. The most pressing issue was the testing of Section 115 and 117 of the Criminal Justice Act 2006, which would also call into question Section 113 and 114, because Section 113 and 114 give definition to the term adult behaviour warning found in Section 115 and 117. So if these sections rely upon Section 113 and 114, then 113 and 114 must be tested along with 115 and 117 in order to test 115 and 117 comprehensively. You can't test 115 and 117 comprehensively without testing 113 and 114. And any barrister at law should know this. So what we're seeing now is an absolute corruption of our court system. If they tested Section 115, 117, found them unconstitutional, all my convictions would be quashed without being able to be appealed. And that's what should have happened. And that's why it didn't happen. Because they're running away from having to remove those sections, from having to admit they were wrong, from having to admit that there was a corruption of court, for having to admit that guards don't have jurisdiction in civil matters and therefore can't issue behaviour warnings. If they cannot arrest you, they cannot tell you to stop doing that behaviour. If they can arrest you for doing that behaviour, they can tell you to stop doing it. They can issue a cease and desist order that has been first issued by the court, not out of their pocket, playing judge, jury and executioner on this side of the street. This is an absolute corruption of law. It's corruption of Western society. This is huge. And so the fact that an appeal is even entered into the Court of Appeal shows the degree of corruption within our court system. They need to submit that they have to test the constitutionality of Section 115 and 117. They need to submit that today they have not established jurisdiction because the appeal was a month and 4 days late and no extension to appeal was applied for. It's as simple as that. They cannot sit today or establish jurisdiction because no extension to appeal was applied for, and therefore no appeal was applied for, because you can't apply for an appeal without first applying for an extension to appeal. This is basic administrative procedure. The fact that the Court of Appeal have overlooked this a month and 4 days late when the High Court ordered that the convictions be quashed is an absolute manipulation of our systems and a corruption of our court. So they have to do what is according to the laws of this land and do it quickly, because they're way out of line. And if this is being done intentionally, committing high treason against the Irish people. And I believe it is being done intentionally. That is my solemn belief. So I'm entitled to my beliefs and opinions, and I have proof to back it up, because all the way along they've been manipulating here. They've been giving notification to the council that used to represent me that they know I've dismissed and that the court has accepted are dismissed. They've been communicating to them to issue me partial information as to what was upcoming in the Court of Appeal. They didn't give me any final date to get in contact with them, but over 2 weeks prior to today's date, they told me that the appeal was going to be unopposed because I hadn't contacted anybody. Now, can you imagine a Court of Appeal saying that the appeal is going to be unopposed in a matter that would see somebody being in prison for 7 months, yet they'll accept an appeal a month and 4 days late? Now they're saying that they're going to hold the appeal remotely so that I can't even enter into the court. What sort of corruption are we seeing? This is an absolute hideous corruption that we're seeing. And look at the treatment they're giving me. Look, -2 degrees. They're absolutely out of line and out of order. It's an absolute corruption of our country, and they need to be called into line. In Jesus' mighty name, so be it. Blessings in Jesus' name. Today there will be a hearing in the Court of Appeal for Stephen Tallon versus the DPP, even though the Court of Appeal hasn't established jurisdiction for the aforementioned reasons. And guards shouldn't be operating out of jurisdiction. It should have been noticed at district court level, let alone circuit court level, let alone high court level, let alone Court of Appeal level. This should have been noted early on. What is this superintendent doing in this civil court? Blessings in Jesus' name.